Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Just a very quick bankruptcy update. On June 21st, 2022, the President signed Senate Bill 3823 into law, called the Bankruptcy Threshold Adjustment and Technical Corrections Act. Most of this new law has to do with changes in Chapter 11 of the Bankruptcy Code, but what I want to discuss here is the big change made to Chapter 13. Chapter 13 bankruptcy is, in essence, a repayment plan, a reorganization of your debts. The Bankruptcy Code refers to the chapter as an adjustment of debts of an individual with regular income. Chapter 11 is also a reorganization of debts, but it's mostly used for businesses, although individuals can also file Chapter 11 under the right circumstances. In Chapter 13, you propose a plan to address some repayment of your debts. And the problem for some people who really have a high amount of debt is that they don't qualify for Chapter 13 because they have too much debt. So unlike Chapter 7, which doesn't have a minimum or maximum amount of debt in terms of a limit, Chapter 13 limits who can file based on the amount and type of debt that they have. So before I tell you the new amount, let's quickly discuss the old amounts. So for the past few years, the limitations have been separated into two types: secured debt and unsecured debt. And the Bankruptcy Code says that only an individual with regular income that owes on the date of the petition, that's when the bankruptcy is filed, non-contingent, liquidated, unsecured debts of less than $465,275 can qualify as a debtor in a Chapter 13 bankruptcy. And it goes on to say that only an individual with regular income that owes on the date of the filing of the petition, non-contingent, liquidated, secured debts of less than $1,375,875 may be a debtor in a Chapter 13 bankruptcy. So the amounts, those exact amounts, they change every 3 years. And those particular amounts went into effect April 1st, 2022. So what this new law does is gets rid of the distinction between unsecured and secured debts and simply says that if the aggregate total of your debt, both secured and unsecured, is less than $2.75 million, then you can file a Chapter 13 bankruptcy. Of course, if you meet all the other requirements. So for consumer cases, it used to be unusual to come across a debtor with more than $465,000 of debt, unless they lost a large lawsuit of some kind or something of that sort. But with the rise of student loans on top of regular debt, it's becoming more and more of a problem because there are people who make too much money to file a Chapter 7, but they also don't qualify for Chapter 13 because they have too much debt. And the court has to take into consideration debts that don't go away in bankruptcy, like a student loan or a mortgage on a house that you intend to keep. So the secured debt for consumer bankruptcies really hasn't been much of an issue for the cases that we do, because in Indiana, most houses don't cost nearly that much where you would owe more than $1.3, almost $1.4 million. But in California, for example, where a 3-bedroom, 2-bath, 2,500 square foot house could easily put you in that territory, it's been a problem. So this $2.75 million threshold will provide some breathing room for some people now who couldn't file bankruptcy a couple days ago, and now they do qualify today. Now, there's one strange thing about this law, and that is that it contains what is called a sunset provision, meaning that unless Congress takes further action to make the law permanent, it will expire on June 21st, 2024, and the numbers will go back to the old numbers that we just previously discussed. So stay tuned for updates, and we'll see what happens in the next couple years. But that's it for today. Please click like if you like the video, click the logo at the end to subscribe, and as always, thanks for watching.